Welcome back to the 4% Business Owner TV channel. We are actually the Intentional Wealth channel. I think the 4% TV is a show within the channel because there are a few videos I want to add that are more educational around sales, strategy, that might be more webinar based.
Okay.
That'll be a separate show within the channel.
Excellent.
You get kind of inspired as you look at this. So I was driving in today realizing we're going to be doing a series on trust. This is going to be part 1 of 2, which also goes with some information on how do you build rapport in sales. Because I think arguably trust is the biggest, most important piece in your business.
Trust drives client relationships. It drives interactions among employees. It drives interactions between managers. It is the underpinning of the communication of an owner's vision and values in their business to their employees. That's all based on trust.
And so knowing how to build trust is one of the first things you're taught in sales. How do you build rapport?
Right.
Which really is about building trust. And so understanding how important it is to be able to create trust is a big step. It's a communication skill. It's a leadership skill. It all comes, though, from self-trust, self-confidence, knowing your strengths, knowing the vision that you're creating so that you can project that self-trust out and be able to share the confidence that you can do what you say you can do.
Right.
So building trust is huge, but what we're actually going to talk about today is protecting that trust once you've built it. It can be such a rare commodity that when you find that trust in existence between your business partner, between you and your ideal client, it can be so exciting and so magical that you don't even worry about protecting that trust.
It's you feel empowered. You feel able to tackle things, knowing in your perspective, within your own perspective of having somebody have your back. You're quite sure, but until you have that discussion, the trust framework or the trust basis is not established or articulated, at least.
And as a coach, I also see that I know what I mean when I say that I trust that we're building this thing together. And you know that you know what you mean when you say we're building this thing together. But the unspoken assumptions are the things that can get in the way.
Absolutely.
So even when I know I can trust you completely, that doesn't mean I know what I can trust you to do. Because you'll do what you think is best.
Right.
And every behavior you do will have the greatest powerful positive intention. It just may not match what I expected as my unwritten, unspoken intention. So our partnership here at Podium Prosperity is pretty darn brand new. We've been working together for a couple of years. We're formalizing it this year.
We are.
And one of the things that we are doing is what I think everybody should do at that moment of, we know we love each other, we know we trust each other. Put it in writing, specifically what that means. And we're building a shareholders agreement.
We are. It's the crucial tool. If you're in a business and you have a business partner, or partners that are part of the shareholding group, that document is one of the most important documents that you can put in place at the beginning of the relationship. It's not something that can be done later on once a disagreement arises, because you're never going to get agreement on the document. The document's how you're going to deal with disagreements if you have a disagreement. So very important to get it done up front.
And it doesn't imply a lack of trust. In fact, it values that trust so highly that we want to clarify it. We want to put it on paper. You really need to build a place of non-judgment, no fear, a really safe container in which to have the conversations around that shareholders agreement, and really becoming at it from that perspective of, I trust you so much that I think we can build something very specific together.
It results in a document. And we often say to clients who are working on the shareholders agreement that you're going to write this thing, and if the trust is earned and respected, and if the business goes the way that you and your partners think it's going to go, it's going to get tucked in a drawer and never used. So the value in the case of a problem is the document, but the value of the process in coming to that document is what establishes the platform for moving forward in trust on your business. Let's be perfectly clear about what we mean when this happens.
And people are a little scared to have that conversation because it implies
Terrifying.
the opposite, right? It implies a
Yes.
lack of trust or a fear that things are going to go wrong.
Or a fear that you might find out that you're actually not on the same page in some fairly consequential area of the business. But always better to know.
There's a couple of examples that I sometimes will bring out. So one of them is sex ed, grade 10 sex ed. You probably were told you need to have the talk about STDs, you need to have the talk, when I was young, you need to have the talk about AIDS, HIV. And kids would be like, I couldn't have that conversation. And then the teacher would say, if you don't know that person well enough to have the conversation, you don't know the person well enough to do the act. And it's just a very powerful statement for every place of trust that you put yourself. If you aren't comfortable having the conversation about what if things go really wrong, what if things go really well, then maybe you're not ready to take that step.
Right.
Having that statement out there can take away some of the judgment and fear about having the conversation too. That's like, no, we do know each other well enough to do the what ifs.
And while every conversation between business partners is going to be pretty unique to their business and their relationship, the great news for business owners who need to go through this process, and that would be all of you with partners, is that there are extremely well established frameworks and models to guide you through that discussion. It's not a free-form thing. It's not a thing that is going to drag on for years. There are some really, really, really good templates, I'll call them, because every partnership should, and many have gone through this process. So it's a very progressive, well-established, here are 30 things you're going to need to talk about.
I think that framework is also a place that takes away the fear and takes away that concern about, well, why are you bringing this up? I'm bringing it up because it's part of the framework.
Absolutely.
Oh, not because you think that I'm going to run off to Costa Rica and leave you holding the bag running the company as the operations manager while I live off the profits.
Yeah, this question is the question that every set of business owners have to ask themselves. It's not about you or your partner or addressing a particular risk. It's this is what all business owners need to think through when things happen in their business, whether they go way better than expected, because that creates an interesting set of things, or if they don't quite go as expected and you need to manage through some deviations in your business.
So we're going to dive into that framework, but before we do, I just want to bring in some of the neuroscience of why now? Why do the shareholders agreement while you're still in that place of stars in your eyes, lots of trust, lots of hope, lots of love, getting it writing now and not waiting. Not even waiting a year to see, well, is our business going to succeed? Because our brains are brains. They are made up of three pieces. When you are at your best, your human brain is online, you are functioning with creativity and trust and play and problem solving, and it's fantastic. Under chronic stress or long-term stress, what happens is you your human brain actually kind of shuts off and you move into your emotional brain, or worse, into your survival brain, that reptile part of your brain in which it's fight, flight, freeze, or appease. All of those behaviors in yourself are dangerous, in your partner are annoying, because you're not accessing the logical part of your brain, the wise part of your brain. That's not a time to start hashing out an agreement that is fair, equitable, that assumes the best in each other. It's not a place of resources that allow you to be your best self. So having this conversation, following a framework that allows you to be curious, non-judgmental, kind of approach your entire business with that beginner's mind in this place where you love each other now, get it on paper now, makes so much sense.
Excellent. I didn't know the neuroscience of that decision-making process. I know you've talked before about, I mean, I think of it in a lay sense of not being able to think clearly under pressure sometimes, but it's interesting to understand the neuroscience of the regression back to, and that's it's a good picture, the reptilian brain, right? You can think of crocodile kind of being angry at something.
And you can really feel that way, right? When you think of times when you were really anxious or very stressed, you pulled into this reactive, knee-jerk place, and you've got tunnel vision, literally and physically, but also metaphorically.
Right.
That you can't see the full picture. You don't waste resources on seeing big picture when you're in that mode.
Right, and if you hopefully have been through this process of documenting what the intentions were, that should allow you then neurologically to come back into being a human being in terms of the discussion, because you've documented what your intentions were at a time when you were thinking clearly and unstressed.
Exactly. In fact, if this process goes as well as it typically does with our clients, you're building in all that trust and faith and hope into the document. So when you pull it back out again and dust it off and start to go, that says we should be doing this, okay, right. I remember when we created this and we planned on this. So it will awaken that sense of who were you being when you wrote the document, right, as you start enacting those things, should that happen, right? Should that be something that does occur? Hopefully not. But if it does, then it's just a very simple, do this next. Yes. And you can do that from that state of mind.
Yes, and I have to reiterate, that sounds like how could we possibly contemplate all the scenarios? But these templates that have been developed over years and years and years of corporate practice and corporate legal practice, and have been subjected to litigation and courtroom. So the framework that we're using today is extremely robust and is general enough to essentially capture all possibilities without having to lay out in detail every possibility.
Yeah, I love that. And one of the things that Jim often draws attention to is people say, but my business is so complex. Yes, all businesses are complex and simple. Their complexity stems from a set of very simple things, and there's 7 items in the framework, and I'm going to get you to just list through all 7 of them first,
right? And
then we'll dive into some for instances for each of them, and maybe some of the phrasing of it. So from the top, what's the framework that you like to work through when you build out a shareholders agreement?
So in shareholders agreements, people typically talk about sort of the 3 Ds, if you want to think about it. We've expanded that in the way we talk to clients about getting this kind of work done, which is work, by the way, in the end that is done by a lawyer. You want a lawyer draft your agreement. But the business discussions around that, we've identified 7 Ds. Decisions, dilution, disability, death, disagreement, departure, and details.
So handy that you force them into the Ds.
I just, love alliteration and acronyms.
And then we need to pull them out of the Ds and go, okay, now what does that mean?
Yes, exactly.
So let's start at the first one that you mentioned, which was decisions.
Right. So under corporate law in Canada and in each province, there's a set of legal rules around who gets to make decisions in corporations. And those rules are oriented towards large businesses. In a business, in a corporate structure, the decision-making authority legally rests with the board of directors. And the shareholders get to elect every year the board of directors. But in a small business, of course, the directors and the shareholders are the same people. So in order to remove or to supersede, if you want, the legal structure that says the board of directors makes decisions, in a shareholders agreement for a small business, the shareholders decide to pull some decision making out of what would legally be the board's responsibility and make it a shareholder responsibility. So a very good example of that, for example, is you would want to agree as shareholders that no one could make a decision to get the company into a debt obligation, borrow money from a bank, that maybe is more than $10,000. So if that's going to be done, if somebody wants to borrow $50,000 from a bank or $100 or $250, that comes back to the shareholders for decision making. So there's a raft, it's basically a checklist of the typical things that business owners usually want to reserve for shareholder decisions rather than the default legal board of directors kind of decisions.
And it can be tough to feel like you're ready for it because you haven't confronted these decisions yet, but being able to just go through it as a checklist, you can start envisioning into the future. A lot of building business success intentionally is envisioning the decisions of today and the future decisions,
right,
so you know where you're steering yourself and how. So that would be a fun first place to start, I would think.
Yeah, it's relatively easy. It's a checklist. One of the things that we're able to do with clients because of our experience is to say, normally a set of partners would agree that $25,000 is the limit. And then you can decide, we're nervous about debt, we want to make it lower, or we're actually going out to borrow money now, so let's make it $100,000. So you can, we'll let you know what we think the normal range is for those decisions, what's normal in those kinds of decisions, and then you can adapt from that. And you can actually revisit. So if you're two shareholders today and you've got a company making $1 million a year and you don't think you need any debt, so you set that limit at $10,000, 5 years from now you might be a $10 million company and you actually need a consequential bank loan to buy a new machine. You might go back to the shareholders agreement and amend it and increase that limit to $100,000 or $250,000.
So in the absence of this documentation, I could imagine people sitting there in their first days of incorporating going, I don't know, do you want to be the CEO? What should I be? And a ton of assumptions would come from that, right? Well, I'm the CEO, so the buck stops here on all decisions.
Right.
Which could be totally inappropriate.
So not getting into, I think we could have a whole show on corporate governance.
Yes, we probably will.
And we probably will. So as a quick summary for those of you who are interested in this kind of stuff. So the board of directors legally has responsibility for the decision making. The shareholders have the responsibility of electing the board of directors to represent them. And the board of directors has the responsibility for finding and appointing the chief executive officer, who then hires their executive team. So the CEO is the delegate of the board of directors to actually run the company, because the board's job is not to run the company. So in a small company where there are two shareholders and two directors and one CEO and one president kind of thing, which is typically how things end, or one's officially legally the secretary and one's the president, it's not typical to structure the governance all the way down to the management of the company that way. This list actually forms your decision-making model as between the two shareholders till you get much larger and have a much larger team at your disposal.
So what else could happen if you have not taken the time to look at the decision-making? Have you seen any situations where things have gone wrong because they have missed this step?
Again, not a lawyer, but at law, officers are empowered to commit the corporation. So if you're an officer of a corporation, and you can think president or secretary or chief financial officer, or CEO. If you're an executive officer of the company, you can go out and obligate the company to something. And if you don't have a set of decisions, a list of decisions that say, hey, you can't do that, and one of the partners goes out and, I don't know, decides to buy a competitor, decides to buy something without talking to their partner, like heaven forbid that happens, or makes an obligation that now obligates the corporation, this kind of decision-making tool and list is intended to bring everybody back to before the decisions are made, to bring everybody back to, hey, we have to decide this stuff together.
The conversation itself would be amazing too. I'm thinking about one of our clients who, one of the partners goes out and hires and changes their service model. Says, now we're doing this, without talking to the other partners, which might be brilliant and exciting and fun for that partner, but the others may feel lost in that situation, may feel disregarded in that situation, even though in operations it might be a wise decision. If you haven't had this conversation ever, it is hard to start having those conversations later. And
very particular. That's a very good example where you might be sitting there as an owner of, I don't know, a manufacturing entity and say, okay, do we need to list specifically what my partner can or can't do, or what I can or can't do in the context of my specific manufacturing business? There are general words in that kind of decision making specifically about, nobody in the company without the shareholders' approval shall undertake or materially change the nature of the business. Right? And that's intended to be a generic catch-all. If you're in this business, you can't be a taco stand. Like, nobody can go out and buy a taco stand to, diversify.
Unless we all agree.
Unless we all agree. That's exactly right.
Excellent. Okay, so that was just the first one, decisions.
Yeah, that's decision making.
That's a big one.
It is.
Next up?
Next up is dilution. So that is very specifically around the ownership of the company. So when you got into business, you might be equal partners at 50-50, which causes some interesting discussions because nobody then actually has control of the company. You could be 51-49. You could have someone who brought more capital to the business or is going to be full-time and the other partner's not full-time, and you might end up in something other than a 50-50 relationship, a 60-40 or a 70-30 relationship. At some point in the future, the ownership of the company is going to change. And there are a whole bunch of reasons why that might happen. But one of them is the company may need more capital. So you founded the company, you each put in $100, you built it from the ground up, you maybe borrowed money to grow your business, but there comes a point where the bank looks at your investment in the company and goes, listen, we'll lend you more money, but you got to put your own money in. So one of the ways of doing that is to sell shares to possibly you as the existing business owners, but you may decide to bring in more skills, and those new skills may want an equity stake in the company. They may want to be shareholders. Bringing in new partners or thinking about how to raise capital in the business that involves issuing new shares can be quite fraught. And the typical fallback is if the company needs more money, the general clause that people put in is they have to come to the current shareholders. Right. That can be a problem if one of you thinks you need new blood and the other one thinks you don't need new blood. So these kinds of dilution discussions are all about how do we get to the point of agreement in bringing in either new partners or accessing capital that we ourselves don't have. So it can be a source of irritation down the road. It's a future-oriented thing.
Right, and only in a growing company, of course.
Yes.
Right. So something that you're betting on the success of your company, even though you can't envision it yet. So having these conversations up front can feel a little silly. But then 3 or 4 years from now, you look back and go, wow, we really have built something incredible.
And that's where the value of the template comes in. You're not the first people going through this discussion, and these clauses have been tested in courts numerous times. And as long as you know what you want to have happen, there is a standard way to document that so that it doesn't cause a problem down the road. And if you don't know what you want, there are standard clauses that are the default, I guess, for those kinds of decisions.
Excellent. Yeah. All right, I think I understand dilution.
Okay.
Next.
The next thing relates to one of the shareholders, one or more of the shareholders becoming the broad term for it would be inactive. And they're either permanently inactive because they die, or they're at least temporarily but possibly permanently inactive because they're disabled. So this all has to do with what do you do if one of the because in a small business, the shareholders are typically also the people doing the work, at least or especially in the early days. And you're relying on each other or you as among a group to get certain things done in the company. So let's say you've got a group of 3 shareholders, and one of them is the president, and one of them is the operations person, and another person is the finance and human resources person, and your operations person dies. They hold the shares in the company. What happens to those shares? Do you, the surviving shareholders, buy them back? Because the estate of that deceased shareholder is going to want to see value for those shares, assuming they have value, which is a whole different discussion as well. But if they have value, do you, the surviving shareholders, buy those shares? Does the company buy the shares back from the estate? Do you reserve those shares and bring in a new operations person and have the new operations person buy the shares from the estate? So there are a number of different consequences that need to be thought through there, including some fairly significant tax consequences on especially death of a shareholder. Consequences to the estate, consequences to the surviving family of the deceased shareholder, consequence to the surviving shareholders. And how you document that, if you document that in a way that doesn't respect the tax consequences, you can end up with some really unfortunate results that could have been anticipated that weren't properly anticipated.
And so I don't just, when I die, my daughter gets my shares.
Yeah, so the typical, thanks, Cher, for that. And by the way, Christy's lovely.
Yes.
The general thought process in the clauses that deal with the death of a shareholder are that the surviving shareholders probably don't want to be in business with the beneficiaries of the deceased shareholder's will, which is not always the case. If you have a family business where you've got couples working together, it might make sense for the surviving spouse of the deceased shareholder to take over their shares. So there are situations where that is the right or might want to be the right outcome, but usually the surviving shareholders don't want to be in business with wherever it is that the deceased shareholder would direct their shares otherwise. So sometimes those clauses around death of a shareholder demand repurchase of the shares from the estate so that they can't actually be directed to someone else in that person's family.
The disability one, I think, could be a fascinating discussion, because how do we decide I'm disabled and can't perform to the level that's required in the company to officially not be part of it, which is a separate thing from we already know, you're done.
Disability clauses in shareholders agreement have the same complexities and difficulties that we see in the insurance world. So in the insurance world, where you're talking about the death of a policyholder, they either died or they didn't, and it's pretty clear, and the insurance company pays if they died, and they don't pay if the person's not dead. But in disability, as you may know from the proliferation of personal injury attorneys, there is fairly frequently a disagreement between what the insurance company thinks of as being disabled and what the person suffering this disability thinks of as being disabled. Did you lose enough
fingers to really count it?
What can you actually do in terms of work to get it done? So, capturing what you want to do from a disability perspective is partly dependent on what is defined to be disabled. And so you can, in a shareholders agreement, capture what you intend to mean by disabled, but the more typical way to do that is for the partners to each have disability insurance policies, and then to rely on the insurance company's definition of disability. So if the shareholder's still on disability, then they're disabled for the purposes of the shareholders agreement.
Oh, that's brilliant. And
It's
also
easy.
not charged with emotion.
It is not. There might be some dispute between the disabled shareholder and the insurance company, but that gets resolved through personal injury lawyers and appeals and that kind of thing. But if you rely on an externality, yes, then there's not the angst of, I think you should come back to work because you look fine to me, of course.
Or I don't think you should be at work because you're not really functioning.
Right. So there's the reliance on an external party in that case sometimes is the easiest way to not have to try to document legally what it means to be disabled for the purposes of your business. It's a simpler way to do it. Unfortunate for everyone, but a simpler way to do it. Yeah.
Excellent. Next up.
I'm going to deal. There's an interesting order here, and I'm going to deal with disagreement first. Ultimately, irrespective of how you document the shareholders agreement, it is sometimes the case that the shareholders arrive at an impasse. So no matter how well you document, there can be differences of opinion in how things are interpreted, and in the end, there's a need to break the company up. So the shareholders need to go their separate ways. There's an irreconcilable difference, I guess, in a marital sense, very similar. You're married to your partner, and then you don't want to be married to your partner anymore, and it doesn't matter what the prenup said. That's just dealing with details. You fundamentally have to break up. So the disagreement clause in a shareholders agreement, sadly, is called a shotgun clause.
Right.
And we occasionally have clients who shy away from the use of a shotgun clause because it implies when you document it, when you're having that upfront discussion, when trust is high, it's a very uncomfortable thing to think about. There's this final recourse tool that we're going to use if we cannot reconcile ourselves to sorting it out. There's this thing called a shotgun clause, and as a result, people are uncomfortable talking about the nature of those kinds of disagreements. The other thing that a shotgun clause can cause is if there's an economic disparity between the partners. So if you have a wealthy partner and a not so wealthy partner, shotgun clauses tend to favor wealthy partners.
Right.
So that's a thing that needs to be thought about. But the way that works ultimately is in a shotgun clause, one partner makes an offer to the other partner to purchase the business, and the other partner gets to decide if they're going to up the bid in order to buy the business from the other partner. So when you trigger a shotgun, you never know if you're going to be the owner of the business or the buyer or the seller. You just don't know until the dust settles, which is very uncomfortable, but it keeps people out of court.
Right.
Because the next position after a shotgun, assuming that you have a mediation clause, and most people say, no, first we mediate, and then if it can't be resolved or arbitrated, then we go to this shotgun clause. But if you don't have the shotgun clause and you can't agree through advocacy or mediation, then you're going to end up in court. And companies have been bankrupted and people have been bankrupted pursuing each other in court because they didn't have a robust, call it a shotgun clause.
And realistically, back to our brains, we are meaning-making creatures. Nothing has any meaning unless we give it to it. Mm-hmm. So just as that superstitious level of I don't want to make a will because I don't want to believe I will die, writing a will does not lead to death. Creating the shotgun clause doesn't mean that you don't trust that person, doesn't mean you'll ever have to use it. It's only if you tie that meaning to it.
Right.
And so when you're going through the framework with us, we intentionally don't create that meaning with you. Mm-hmm. That's not what it means. It just means that your shareholder agreement is complete when you have the full framework covered. Right? Again, taking out the emotion, taking out any inappropriate meaning that could make you fearful.
Right.
It's, again, similar to the idea you said of a prenup. having the prenup doesn't mean I'm intending to divorce you.
Right.
And it does not insert that into our future. It just creates a place of calm, rational decision-making while we still love each other so much.
Clarity. Very much clarity. So we have had discussion with clients who are so uncomfortable with the idea of a shotgun that they don't want it in there. But you need to know that it's likely, if there's a disagreement and you don't have a shotgun clause, that you are going to end up in court at some point if the company has value. And we have clients where that has actually happened. So that is the thing that happens. That's how these shareholder agreements end up having jurisprudence and precedent wrapped around them, is often because of that. Because the judge will go through the shareholders agreement based on what the nature of the dispute is, and it'll get adjudicated that way.
And it isn't just let's insert the clause. It really is, let's think about it. You actually have to say, how would this be fair if it did happen?
Right.
We don't want to be doing that thinking for you. So you do have to get comfortable with it. You do have to take that emotional charge out of it and just go logically.
Well
In the end.
worth taking the time when you're putting your shareholders agreement together. It's often a perfunctory thing that's done on incorporation with the lawyer often who's incorporating you. They'll say, do you have a shareholders agreement? You'll say no. As I said, these things are templated things, so they'll pull a templated thing. They might spend a few minutes going through it with you to make sure you kind of select the clauses that you want. We would recommend a more in-depth process, a guided process to go through that document, because there are sometimes general clauses that don't suit your business and may not suit the relationship that you have with your partner, and this is another session we'll have to come to sometime. It's necessary to put this document in place, but unless there is capital available to deal with the outcome of the clauses that you've documented, then it's a bit of a sterile document. So if you've got a clause in there that says, hey, if you die, I'll buy the shares from your spouse, that's nice, but then you have to come up with the money to buy the shares from your spouse. There's a whole economic discussion around that as well that needs to be thought through and can impact the terms of the shareholders agreement.
And we do tend to work with people with families, right?
Very much.
I've been adopted, so our family business serves a lot of family businesses, and that adds interesting layers of complexity and concern and a lot of levels of assumption that should be just put right out there in the light, spread on the table in black and white, so that everybody knows, not just you, but your children as they mature and become adults and maybe join the business, so that doesn't become a whole new set of, but when Dad and Uncle Jim put this together, it was intended that I would do this. Having it written out and then updated to match what's true.
What's evolved, yes. Yeah. And the second to last D is departure. It is very possible that at some point one of the shareholders will want to leave.
Like you might want to live in Italy.
I might want to live in Italy. I do want to live in Italy. I'm just not there yet. So the question there is, how separate, and we have lots and lots of discussions with clients about this, your role as shareholder and your role as employee are different things. And they're often confounded, and confounding them causes problems. And the problem that it typically causes when somebody wants to leave the business but keep their equity is, are you allowed to do that? If I need you as my operations partner and you decide you don't want to do this anymore, but you really like the company and your shares are worth a bunch of money, do you get to take your equity with you? And if you take your equity with you, how do I replace you if the person that's coming in behind you also wants to be a shareholder in the business? And if I issue new shares, then I'm diluting, I'm reducing my ownership share because the person who left that was operations is keeping theirs. So now I'm bringing a new partner in, but I own less of the company. So it really needs to be thought out, and really the crux of that discussion is, how do we treat the role of employee and the role of shareholder in this company as it relates to the ownership?
Right.
Those are very useful and powerful and necessary discussions. It's one of the ways of not being in business together, essentially, certainly operationally.
What's fascinating, again, to me, there's conversations you need to have in business, conversations with yourself, conversations with your partner. One of the conversations is about that work optional lifestyle, and is it something that you or I or both of us seek eventually, and what will that look like? When you have that conversation, it means that you start looking immediately at your business as a separate asset,
Yes.
as a separate wealth engine, as opposed to part of you. And it can be hugely valuable to start thinking that way early on.
It sets the idea in motion that, yes, me as an investor is separate than me as an employee. In the early parts of a business, when it's all hands on deck, that can be problematic if somebody decides they're going to take their equity and go somewhere else. So there are mechanisms for addressing that. So one of the mechanisms might be, if you decide to leave the company within 5 years, if you decide to leave the company before we hit 10 million in revenue, if you decide to leave the company before this happens, then the company gets to buy your shares back. Well, at what value? At the value you paid for them, or
There's
at
that
the value
$100 back.
yeah, here's your $100 back, or at the value of the company at that time, and how long do you give that person to come up with the money in order to? So there are a suite of decisions there. Again, they're templated and they're well understood, but that's a very interesting discussion as between partners as to what do we want to do with this business. It's relatively straightforward if at the end of the day you end up selling the business entirely and both shareholders are free of their employment and their ownership, but that's not often the case.
Right.
Yeah. And the last D, and it's last on purpose, is details. The previous 6 Ds that we talked about involved very clear, very thoughtful discussions between the owners of the business to make sure that there's a clear understanding, and it's very typical going through this process that you have different ideas as shareholders of what you think needs to happen in these circumstances, and the decision-making process allows you to come to a consensus. The last thing is that this is a legal document. It's wrapped up in a bunch of details. So is that going to be governed under the laws of Canada, the laws of the province of Alberta, the laws of the province of Ontario? Is it going to be under civil law in Quebec? So the details matter to the legal implementation of the document. And usually it's the lawyer that puts all those details in place, but it's a thing that needs to be covered in the document.
That sounds like an easy one.
It's you can delegate that one to your lawyer. Yes.
Another D. Excellent. So decisions, dilution, disability, death, disagreement, which is also possibly dissolution.
Yes.
And departure, wrapped up in the details of where is this
Absolutely.
document being executed.
Yeah.
Wow, it's a solid framework. I love frameworks because they don't leave anything out except emotion.
Right. Yeah.
So you make sure that you're covering everything off in a straightforward best practices, not inventing or reinventing the wheel method.
Nothing new to think through here. Everything that you could think of putting in a shareholders agreement has been put in a shareholders agreement before.
And so to finalize this about protecting the trust that you already have, what Jim really brings to the conversations that we'll have with you is experience, the wisdom to advise and share some ideas of what can go wrong and what can go right when you deal with this point. What I tend to bring to this is facilitated conversations, building the container of non-judgment and safety so that everybody feels heard. Everybody is able to express any confusions. I do a great peanut gallery, like, what do you mean by that? Right? So that you can have just a really comfortable conversation about something that until then you were maybe a little bit scared about the impact of.
Yeah, very, very much. This is the, we were talking about, marriage kind of comparisons. This is very much the sitting down before you get married and saying, do you want kids? Where do you want to live? what do you want to do if this happens? Are we ever going to move out of the country? It's that level of discussion with a business partner. So it can certainly build up in your mind as something that is too uncomfortable to tackle, but with guidance from Share, that does not need to be a painful or difficult or disappointing discussion.
It is funny, the discussions that we put off. That we put it off till tomorrow, we put off our will conversation, we also put off retirement conversations. That's going to be a whole other segment, right?
Absolutely.
Those assumptions of what are we going to do with the wealth we've created when we're 60, 65, 70, wherever it is that where you want to be work optional. Having a habit of having these tough conversations that lead to a very rich life that has peace of mind in it, it's important to make the space to do that. Coaching, consulting is typically the space. We're the part of your team that helps you have those conversations so that they empower and power up your life.
This is an opportunity to put intention into the relationship with your business partners.
Exactly. Yeah. Love that. So this was episode 1 of 2 of how to secure your trust that you already have in a way that is authentic, respectful, and not scary at all, I promise you. So
we're looking forward to working with you on your shareholders agreement.
We are going to have in the takeaway some notes on what are the Ds, but also what goes into, what is the content structure of a shareholders agreement. And when you need help with it, we'd love to be that intermediary to help you explore this at a pace that you don't typically have when you're talking to your lawyer. Right? You know you're racking up some change as soon as you sit down in that lawyer's office, so it can be tempting to rush through this.
They add a lot of value, but there are a lot of thoughtful decision conversations that should be had leading up to actually documenting the shareholders agreement.
Yeah, that legal advice, amazing.
Essential.
The conversation around it can feel a little intimidating to draw out.
Yes, that's true.
Well, I think this was fascinating. I've learned some things. I'm looking forward to seeing our shareholders agreement shape up as we move forward together at Podium Prosperity Group, and look forward to being involved with you on all the decisions that could be challenging and the ones that are just exciting and interesting when we are working with you both here on the channel as well as in the office.
Until next time.
See you then.